In this episode, we will be discussing California Prohibited Residential Lease Provisions. The California Civil Code, Chapter 2, Section 1953, identifies the following types of provisions that landlords are prohibited from using in their rental agreements. Unlawful provisions. Any provision of a lease or rental agreement of a dwelling by which the tenant agrees to modify or waive any of the following rights shall be void as contrary to public policy. Rights or remedies under the laws of our videos, California security deposit transfer when landlord sells property, or California landlord right to enter rental property. The right to assert a cause of action against the landlord which may arise in the future. The right to a notice or hearing required by law. Procedural rights in litigation in any action involving rights and obligations as a tenant. Or the right to have the landlord exercise a duty of care to prevent personal injury or personal property damage where that duty is imposed by law. Lease must be presented before taking possession. Any provision of a lease or rental agreement of a dwelling by which the tenant agrees to modify or waive a statutory right, where the modification or waiver is not void under the law, shall be void as contrary to public policy unless the lease or rental agreement is presented to the tenant before he or she takes actual possession of the premises. This requirement does not apply for lease agreement renewals when the same provision is already in the renewed lease. For additional laws and articles, visit AmericanLandlord.com.